Now, yes, regarding the topic that is there, the topic, as you know, is revisiting Constitution. I told the organizers, Indo Analytics, when they came and met me, why are you calling me? I'm gone old. We have become outdated. I was listening to Mr. Venkatesh. Many of the matters that come to Supreme Court are absolutely fresh. New type of cases. When we were having the Supreme Court, these type of cases we never thought of. But they have all been filed. Millions PILs. And some matters are traveling from the high courts. Right, very difficult. And in one of the latest matter, a notice has been issued by the Supreme Court with regard to same-sex marriage. Right, notice has all been issued.
Why are you looking at me, Lordship?
No, I know he's not thinking in those lines, but I am looking at him. I am looking at him because after hearing him, I find, my God, what kind of thoughts are coming out. So much of original thoughts, young thoughts, we never had in our mind. Right? So I was right when I said I have gone old, outdated. Right? So whatever you listen to me today, don't expect anything that I will say like Mr. Venkatesh. Absolutely fresh slate, fresh ideas. Right? The Constitution was absolutely alien to India's soil. All these things are absolutely fresh thoughts. You can think over that. Many aspects, not only the Constitution. The Indian Penal Code. Indian Penal Code was made by whom? By Macaulay. And it is based on what? On English principles of penal law. In England, there is no penal code. But all those principles of English criminal law, right, have been codified and made the Indian Penal Code by Macaulay. And the Indian Penal Code has been planted in India to experiment it. Right. And what is it based on? Indian Penal Code. The entire lawmaking in England is Benthamite. Bentham's philosophy, utilitarian theory. That if you punish a person, right, if you punish a person, he will not repeat that act because he suffers pain. So on that thinking, the whole thing, pleasure and pain theory, everything has come. Partly hedonistic and partly utilitarian. Punishment, it will deter. And therefore the Indian Penal Code provides for punishment depending on the offence, gravity of the offence. Similarly, the Indian Constitution was not thought on the basis of what was there in India, the original soil. What he says is right, absolutely right. There is no doubt about it. It came from 1919, 1909, 1919 Act. First the 1909 Act, 1919 Act, the 1935 Act. The entire federal structure is made in 1935 Act. Right. Then the Constitution of India, 1950, the Constitution of India. So it has evolved. It has come in an evolutionary manner from whatever was there, and it was built up on that. The fathers of the Constitution have built up the Constitution on the basis. We didn't have a presidential system, right? In the 1935 Act, we had a parliamentary setup. So, and that was the British setup. This was followed here, a parliamentary setup. We could have thought of a president setup, right? Like a prime minister like Mr. Modi would have made a very good president, right? With checks and balances, one man show. They say now in India it's one man show. So, but we had an evolutionary setup, evolutionary constitution, which was really thought of by the constitution makers and made. To that were added the fundamental rights. Those which could be enforced should be enforced. Part 3 of the Constitution. And those which could not be enforced because the country did not have the resources then to make them enforceable, like the right to education, providing a lot of socio-economic requirements. All those things could not be enforced. They put it in directive principle of state policy, and they said that these are the, basic principles that the legislatures and the executive must follow. Because that time they didn't have the resources. Right. What the Supreme Court has done is, gradually picked up one directive principle of state policy and incorporated a fundamental right and enforced it by expanding Article 21. It was there earlier, directive Article 46 was there, right to education up to the age of 14. Right. That has been picked up in Unni Krishna's case and put as part of Article 21 and said right to education is a fundamental right up to the age of 14. This is the beauty of the Supreme Court. Wonderful beauty. See, it was not thought of as a fundamental right, but they have brought it from there. And they have said, now the economic resources are sufficient. Without education, there can be no dignified living. Therefore, it is right to life, and they have incorporated. The Supreme Court has incorporated, environment. Environment was nowhere in the in fundamental rights. They have put it as fundamental right, Article 21. Right. Right to privacy. Now it has been incorporated in fundamental right, Article 21. This is the great job the Supreme Court is doing. With evolution, and as and when need arises, new situations come up, new debates come up, and new circumstances lead to Supreme Court taking a fresh view of that very small article, Article 21. Right? Every person, a person shall have a right to personal liberty. And nobody's personal liberty can be taken away without procedure established by law. Right to life and liberty. Or right to life and liberty goes Gopalan case, they said, very narrow interpretation they gave. Only statutory law, protection in statutory law. In statute, whatever protection is given by statutory law, that protection. But ultimately it has expanded. Right. And then they have said, no, Article 21 is a great right. And they have incorporated many freedom, many liberties. That is how the Supreme Court has expanded the rights. But there are certain areas which the Supreme Court cannot. He has very rightly said, Constitution for 100 years. I would say now the Supreme Court said basic structure is there. Basic structure cannot be altered. The Constitution for hundreds and hundreds of years. When there will be a revolution, then there may be a new Constitution coming in. Right. But till that revolution takes place, it's very difficult for any government to undo the basic structure. Once they have held it, unless now, this was a 13-bench judge, 15-judge bench says, comes up and there is no basic structure. Then the whole law will change. That situation may also come. We don't know. Situation may come in future where 15 judges may sit and say that judgment of basic structure theory we overrule. You remember? Kesavananda Bharati case, 13 judges came much later. First thinking was of the Supreme Court, Shankari Prasad, the Union of India, that every portion of the Constitution can be altered. Then the law came, I think it's Goloknath, fundamental rights cannot be altered. Right? Then the law came, no, fundamental rights can also be altered, but basic structure cannot be altered. And what is basic structure? From time to time one has to decide. You see how the Supreme Court is adapting itself? Either Parliament and the legislature get together and amend the Constitution to take care of the needs, changing needs of the society. Or, when that is not happening, Supreme Court can, within the parameters of Constitution, expand a particular article and say something more and adapt it to the changing needs. This is how it's happening. In other words, there is a continuous process of amendments. Now, the Constitution will be revisited by the Supreme Court by expanding some of the articles. And the other process is going on by constitutional amendment, but that requires a parliamentary majority, and some articles also require majority amongst the states, federal provisions. So this is the constitutional framework. Now what I intend to do is, these are evolutionary things that will happen. Nobody can stop it. It will happen. Nobody can stop it. Parliamentary parties will come, they'll bring in new ideas. Judges will come, new ideas. Tomorrow Mr. Venkatesh may be there in the bench, right? So he may put his new ideas. But that time Mr. Venkatesh will think, I am thinking of this idea, but what do I do? There is a 3-judge judgment and we are only seeing 2 judges here. Then there is a 5-judge judgment, what do I do for 3 judges here? There are 13-judge judgment, what do I do? Mr. Venkatesh's hands are tied. Like my hands were tied in many respects. Do you know, have you heard of my judgment, Lily Thomas case? No. Lily Thomas case is the judgment where I authored the judgment, agreed to by Justice Mukhopadhyay. The judgment said, the provision in the Representation of People Act, Section 8(4), which says a member of Parliament or member of the state legislature, if he is convicted and is disqualified, if he files an appeal against the conviction, till the conviction is decided, he will continue in the House. We held in our judgment, no, sorry, you can't continue. Till the conviction state, you can continue. If conviction not state, you have to go out. Why? We said the Constitution vested the powers in Parliament to make the same law, right, for disqualifying person who want to contest the elections and person who want to continue, who have to continue. So, if you are disqualified by a conviction to contest, you can't continue in the House if you are convicted. And we struck that provision. The result was all the Parliament members got together, all party meeting was held. They wanted to undo the judgment because they were affected. Right? But then thereafter the law could not be passed. They made a law, introduced law could not be passed because the BJP backed out. Mr. Jaitley told me we backed out because we found the Supreme Court has said Constitution does not vest such kind of power on Parliament. How can we make this law? I told Mr. Sibbal and I told Mr. Chidambaram that we cannot do it. And I told our Sushma Swaraj who was there, and we could not do it. And therefore we backed out, they referred to select committee. Right? And in the meanwhile, they took out an ordinance when the Parliament said. And when the ordinance was made and sent to Mr. Pranab Mukherjee, he said, I can't do it also. If Parliament cannot make the law, how can the President issue an ordinance? Same power as President has. So he withheld it. And ultimately you saw Mr. Rahul Gandhi went to the press club and tore off that ordinance and the ordinance was withdrawn. Why? Right. It was withdrawn. And, but remember, I was saying, there was already a 3-judge judgment cited before us by Justice Lahoti. Right? And that judgment said, this was permissible. This kind of a classification of those who are sitting members and those who are not sitting members, those are outside, is permissible under a classification under Article 14 of the Constitution, reasonable classification. And it was cited by the government. How can you strike it down? You know what I did? I dodged it in my judgment. I said, we will not go into the discrimination portion, Article 14. We are saying lack of legislative power in Parliament. If there is lack of legislative power in Parliament, that's a different ground. That has not been tested in the judgment. Right? And we made it prospective. Otherwise, because I called for the statistics with regard to how many persons are already convicted. Right? That statistics law minister told me, Mr. Ashwini Kumar told me, that there are no statistics, we can't get it. I thought if I now hold this, and in Jharkhand government falls, one or two other government falls, then there will be a good ground to bring an amendment. So I said, make it prospective. The result was, only person who fell after that was Mr. Lallu Yadav. All those who were convicted thereafter, they went off. Mr. Lallu Yadav, number of them, Jayalalitha, all. They cannot come back. Right? So, what I am saying is, sometimes you are confronted with a larger constitution bench judgment. And when you are a larger bench, then you can't. You have to, if you want to do it, then you have to distinguish that judgment and cite and go a different track. That is what that, and that is how it got saved. That judgment got saved and still hold the field. Right? Ordinance could not do anything, legislature could not do anything. So it's all question of evolution. This is some things the Supreme Court can do. Judiciary can do, as I said, to bring about change, revisit the constitution, because of changes. But something the Supreme Court cannot do. No High Court can do. And these are the areas which requires to be revisited by Constitution Amendment. And now I'll demonstrate what are those areas. And in these areas, Parliament is not showing any interest. Why? I gave you the example of Lily Thomas case. If we do it, members of Parliament will be affected. Why should they act contrary to their own interest? Right? Those are the areas I will deal. And one area I'll deal also with regard to judiciary. And they all relate to the present debate that is going on. I certainly don't have the wisdom of rethinking over the entire Constitution. I don't have. I frankly say. I don't have. Constitution fathers have made it. They've done a lot of debate. They have gone to the current issues then, and then they have made the Constitution. I don't have that kind of a wisdom to rethink on the entire Constitution and say all the different provisions of it. So what are the areas? Before I do that, let me quote to you why revisiting, which are the areas? Which are the areas which require revisiting? Very nice book written by Gravenel Austin. His book is the Indian Constitution Cornerstone of a Nation. And in the preface of this book, Oxford edition, which is published in 1999, he says, each and every contingency the framers did not foresee. Framers of the Constitution did not foresee. Nor realistically could they have been expected to foresee. A combination of idealism, Constitution father, all the Constitution makers, if you read there, how they came, how they elected, they're all idealists. Pura idealists, not a present day politician. You've seen the latest statistic today. Most of the members who have got elected in the municipal elections in Delhi have a wealth more than 5 crores. Have you seen the statistics? That was not the position then. They used to get elected hard-working people, all those khadiwalas, and they all arrived in the Constituent Assembly, and they were all idealists. A combination of idealism and multitude of issues confronting during the framing period apparently obscured their appraisal of several future contingencies. They could not foresee future contingencies. They were busy applying their mind to then current problems, and they say, this problem may come, therefore we must provide this problem. This problem may come. If you read the Constituent Assembly, you'll see many of the debates. And one interesting thing that Mr. Venkatesh said, I'll point out while I'm dealing with that. Right? How the debates are coming. Now, so this is the problem. But the problem is, if you don't have a provision in the Constitution, the Supreme Court cannot enforce it also. The High Court also cannot enforce it also. Unless a law is made by Parliament or a state legislature. A law can be enforced. But without a law, how much? How much you can enforce? So I am going to delve into very few one of those areas where there is no provision in the Constitution. Result is, the Supreme Court cannot do anything. They are trying to do, going ahead, but then they are expressing frustration, leaving it. Why? Because the Parliament is not doing anything. Many of the judgments, they are helpless. Right? They want to reform, helpless. So, what are those areas? First area. Now, you all know, in a democracy, political parties are a must. Without political parties, there cannot be any elections to democracies. Right? But you will be surprised to know that there is not a single provision in the Constitution on political parties, regulating political parties. What happens? Congress, dynastic politics. SP, dynastic politics. DMK, one dynasty. Shiv Sena, another dynasty. Where are the political parties of the type that we think of in Great Britain? The Conservative Party, Labour Party. Nothing. Somebody or the other has controlled it. It is not there in BJP. It's not there in what Prime Minister Modi is saying is right. Right. It's not there in BJP. Right. The RSS may be there, but there's no dynasty there. It's not there in CPM. It's not there in CPI. But some of the parties where the family has controlled it, it remains within their control. Now, is that a political party? Right. And nobody is making a law. Then, we talked about preamble, the directive principle of state policy. The representation of the election commission, they issued some guidelines. They say your political party must be consistent with the constitution goals, so on and so forth. But those are guidelines. There is no law to that effect. Similarly, a political party must have an organization. That organization must be a democratic organization. Nothing is there. Then political party must have an ideology or a program. Where is the program? Where is the ideology? If it's all laid down in the Constitution, these are the requisites of a political party. Right? Or by law, enacted pursuant to the Constitution provision, then you will see it will make a big difference in the political parties. But political parties today, you see, is absolutely got indisciplined. The procedure for membership, who can become, how they will apply, and how a member can be suspended, how a member can be expelled. They should not be arbitrary. Right? Otherwise, one statement you make against the leader, you are suspended next day. One statement you make against you are removed also. So some human being is controlling it. Why? Because lack of regulation. In contrast, I'll show how in other provisions of other constitutions, they have prescribed it. Right? Then, jail body should be able to elect its members in a fair election. अब देखिए कांग्रेस का इलेक्शन होने के कितना टाइम लगा? How much of time it took? Election. Could this happen if there was a provision in the Constitution? Could this happen if a law was made pursuant to the provision of the Constitution? Nothing. So political parties, which is the most important factor in a democracy, they form the government. They come to parliament. They make the laws. There's no regulation in the constitution. And it is not as if political parties were not there. Political parties were there, very much there in existence before the constitution, but somehow they thought they missed out. Why? They thought other political parties, Swatantra Party Swatantra Party was there, Raja Gopalacharya, Congress Party they are all disciplined people, उनमें कुछ गड़बड़ नहीं होगा, गड़बड़ नहीं होगा, idealistic. They thought that. But human beings have turned out to be something else. They are all pursuing their self-interest. This is one area. And I may cite, what will be the consequences? Political parties have become dynastic. Members have become indisciplined. BJP refused some tickets in Gujarat. They turned rebel. They contested. ये कैसा होगा? हिमाचल में भी ऐसे ही हुआ. Even BJP is unable to control. With all the power they have, they are unable to control. Because they have all become individualistic, self-interested. They are not thinking in terms of programs or the ideology. हमको बनना है MP, हमको बनना है MLA. That's all. If this party doesn't, Congress doesn't give, I'll go to BJP. BJP does not give ticket, I'll go to Congress. In local same thing happens. They switch sides very fast. Is this a political party? This does not happen in England. This does not happen in USA. They are real political parties. Right? Then next, defections continue. Right, Mantri Mandal mein. Suddenly you find the Chief Minister is gone. Somebody else has taken away a number of MLAs. More than 1/3 you have to have. You go and form another group and join with the other party, form the government. 10th schedule has not brought about a change. Right, only the numbers must be 1/3. Right. So, these are the problems. There must be a provision in the Constitution laying down some basics of what a political party would be like and how it will be regulated. Thereafter, the Parliament may make the law. Right. Now, I'll give one example. I have studied the subject. Many countries have studied it, but I'll give the best example. That's in Germany. Article 21 of the German Basic Law states that the political parties shall participate in the formation of the political will of the people. They may be freely established political parties. Their internal organization must conform to democratic principles. You see this? And they must publicly account for their assets and for the resources and use of their funds. This is Article 21, the German Basic Law, which is the constitutional law. And pursuant to that, the Political Parties Act 1967 of Germany has been enacted, right? Pursuant to Article 21 of the Basic Law, and it has made all these provisions, right? How the political party will be formed, what are the sources of funds, what will be organizational setup, so on and so forth. So this is first point I am making. The second missing provision is, I am asking all of you, can an election be fought without funds? Tell me. And anybody who goes an independent and tries to contest against a political party with so much of funds, can he succeed? He cannot succeed. But where is the provision in the Constitution as to with what funds a political party will be created or established, and with what funds election will be fought? Nothing. All silent, and yet Parliament is not making any law. I am asking you to think about this. No law. Some provision here and there, Representation of People Act, some provision is there. Some people, their company donation act, was their companies act, their donation there, they banned it. Then black money came in, then reintroduced. Then electoral funds have come, electoral boards have come. These are not. You must incorporate the constitution. And if you incorporate that constitution, a lot of things will change. Right. And I will only quote what change can, I will only quote Mr. Qureshi, S.W. Qureshi, former Chief Election Commissioner of India, in his book, An Undocumented Wonder, The Making of the Great Indian Elections. At page 262, he expressed the view, uncontrolled collection and spending during an election campaign can breed corruption, play hell with the system, and disturb the level playing field among political parties and candidates. That's what is happening. जिसके पास पैसा है, resources है, वो जीत सकता है. I didn't want to be a judge. I want to be a lawyer, and then wanted to be a political leader in contest elections myself. Then I found, baap re, ये तो पैसा का खेल है. I saw one or two elections. One member of the bar contest, I went, it's all money, 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 money. One Mr. Ram Jetpalani came once to my court in Chhattisgarh. He was arguing a bail matter for Mr. Ajit Jogi's son, Amit Jogi. And he started his argument. My lord, is your lordship knows what happened in elections? I said, no. I'll tell you what happened in elections. He said, it's all money. When the candidate stands, there's a lot of money, and people surround him for money. And then the election process starts. Without money, right, you can't contest election. Then nobody will surround you also. I hope some of you have contested elections. No. Go and contest, Mr. Venkatesh. No point, don't stand here. You must contest. You must contest. Then you know what is really the constitution. And many of the leaders, I would say, political leaders, doing a fantastic job. They go to the field. I could never think of doing it. Look at Mr. Modi. How many times he went to Gujarat? What kind of stamina? He's almost my age. I can't do it. Rahul Gandhi can do it, but he's going in the Jodo. He should have been Gujarat. Right? He was right. But this man, 75 years old, with what energy is fighting there? Election. He knows that unless he works, he'll not get the votes. It all resources, efforts, money, everything. So therefore, election funding, how it will take place, how political parties will be formed, with what funds, kuch nahi. There is nothing in the constitution. This is one area where, and mind you, all the lawmakers know that. All those who are sitting in Parliament, they know that. But they are not doing anything. Why they are not doing it? If they know this is a big problem, and Mr. Modi was also saying, why not have elections of states and together? He knows the problem is कितना बार खर्चा करोगे, कितना बार पैसा उठाओगे elections के लिए. Very clear, very difficult. Many chief ministers say, how many times we raise funds? How can you go to the people and ask for funds? Right. But if they know that, why don't they make the law? They don't make the law because Constitution does not make any provision in that. And for this, neither Election Commission can do anything, nor the Supreme Court can do anything. No powers. If the Constitution made it, Supreme Court, some petition would have been filed and argued by Mr. Venkatesh or Mr. Jain. Right. Yeah, this is the Constitution provision. I am filing a PL. Please issue a direction. Please do that. Please do. उसका ही नहीं. क्या करेंगे आप? क्या करेंगे? Supreme Court क्या करेंगे? हमारा हाथ में है ही नहीं. And this is what I've seen Rohinton Nariman expressing frustration. Right. You are not doing anything. You are not doing that. You are not doing anything. ऐसा होगा. How will it happen without the Constitution provision? This is one. Consequences: rich and wealthy influence the political leaders. And there is quid pro quo in policy and executive decisions. I don't say quid pro quo between lawmakers and law to banta hai apna. It's not easy to influence parliament. But at least the executive, the political leaders, they collect funds and give favors. If this is happening, they should make a law, right? Then, equitable social order. I agree with Mr. We should not think of socialism. But equitable social order, socio-economic rights, you have to give to the people. May not be a socialism. It may be also by the liberal policy, by the capitalist policy, whatever it may be. But you have to provide those things to the people. But equitable social order ko to obstruction aata. Number of times the obstruction comes in. And so badly because of the influence of money. If you remember, in the Land Acquisition Act 2013 was sought to be amended by Mr. Modi. But it was given up by him because he found no, the farmers would be affected, the poor will, let the state do it. I will not do it. And that because industries cannot come up. There was difficulty with that law. So, this is the difficulty. If funds are collected from rich and wealthy, the political decisions, the executive decisions will totally go in their favor and the social economic order will be affected. Now, other countries. See, in England, constitution, there is no written constitution. It's a sovereign parliament. But even there, parliament has enacted the Political Parties Elections and Referendums Act 2000, passed in United Kingdom, provides donors. Who will be the permissible donors? Donations for what purpose? Political purpose. Right. Then the donations, how it will be used? It will be used for only expense of political parties, for assets of political parties, and will not be put in the pocket and used elsewhere. Then declarations as to the sources of the donations. All this is provided in that act in England, right? They made an act and done this. The next point that I would like to say is, India is a democracy. Lawmaking should also be made in a democratic manner. See what happens in India. 5 years parliament is elected, or 5 years state legislature is elected. If lawmaking chalta rehta hai. The executive initiates the law, mostly. They have the majority, they get it passed. And the chief minister or the prime minister wants it, they get it done. Right? But lawmaking also means you are going to affect some interests very badly. It may be the farmers, it may be a particular community, it may be a particular area. All these are there. I have seen abroad, in 1976 I had been to US, I found there was a committee meeting going on. Committee meeting of the US legislature, Congress committee meeting. Why? I said, I said that. You know what was they are trying to make a law that those who are traveling in two-wheelers, they must wear a helmet. 76 they were trying to make it. And for that, they were doing a hearing, local hearing. Whoever wants to come, they'll notify it. They'll come and they'll attend the hearing and say whether this law should be done or not. And this law is debated, how it should be done. They'll take a note down. And they'll go back, and that committee will present its report to the House, and House thereafter will make the law and how they make the law. In other words, law should be made in a manner which is also democratic. It should not be passed by, if the chief whip wants, pass. Right? Oppose. ऐसा नहीं. Debate करो, discuss करो, committee में अच्छा study करो. And the committees, they are MLAs and MPs, they hold the sessions for a short time. But the committees, if everything goes through the committee, standing committees, we have a committee system here, but it's all discretionary. If the majority party wants it, it will refer to this committee. If majority party does not want it, it will not refer to the committee. Right? So the committee system must be there in the Constitution. Any law that is enacted must go through the committees. And committees may have the same representation of the political parties as it is there in the House. There is no problem. But they must discuss, they must hear, they must go to areas, meet people, discuss, come back and submit a report. It makes a big difference. This is basic, totally. There is no mandatory reference to committees. In fact, committee is not there. They are going by the procedure that is laid down by Parliament. Right? So that should be laid down. And these committees are there in many countries, in France, in Portugal, in Spain, Italy, Greece, the standing committees. Right? So this is what I'm saying. And the last one is, of course, what is being debated now with regard to judicial appointments. Right? Now, since the matter is in the Supreme Court and matter is discussed, I will not discuss much. But let me tell you, it requires some reforms. Neither the government is happy, nor the bar is happy. It requires some reforms. There is an act passed in England. England, mind you, is a sovereign, but they have felt the necessity. And they have passed what we call the Constitution Reforms Act 2005. Right. I have studied all that. In fact, I am writing a book on this, all these subjects. Therefore, I have studied it. I readily agreed. That book is yet to be published. I am still observing when to publish it. Right. And in that act, you know what is provided? It provides that the Lord Chancellor, who is the law minister there, while making the appointments, is the principle, and then it is laid down, must ensure that the constitutional principles of rule of law and judicial independence continues to be maintained. Right? That are the primary goals. Selection is made. Large, they take from the entire country, region, talented persons, wide-based selection. But selection में ultimately merit पे select हो गए. Then they see whether this person is suitable from the point of view of independence of judiciary or judicial independence, and whether it's suitable from the point of view of rule of law. You may be competent, you may be brilliant, you may be talented, but they will ensure this. And Lord Chancellor has been given this mandate. Lord Chancellor is not told, भाई हमारा पार्टी का जो है उसको आप लॉ मिनिस्टर नहीं हाँ उनका कि हमारा पार्टी का जो उसको देखना है. No. If he does that, मुश्किल हो जाएगा. So that is the test. Right? A test देखिए ऐसा हुआ अल्टीमेटली वो सुप्रीम कोर्ट ने यूके सुप्रीम कोर्ट ने स्ट्राइक डाउन कर दिया ना वो प्रोरोगेशन ऑफ पार्लियामेंट बाय मोरिस जॉनसन लास्ट ईयर स्ट्राइक डाउन कर दिया. लेडी जज चीफ जस्टिस बैठ के खत्म कर दिए. American judiciary is not that independent. They owe their appointment to either Republican Party or the Democratic Party. That was Indian judiciary is more independent. If you owe your appointment to a political party, then you are gone. Right? Judges have to be politically neutral, politically independent, must be committed to rule of law, and most important, must be committed to justice. कुछ भी हो जाए, अपना देखना फ्यूचर देखना नहीं है, अपना प्रॉस्पेक्ट्स देखना नहीं है, अपना एम्बिशन देखना नहीं है, अपना डिज़ायर देखना चाहिए, अपना बच्चों का क्या होगा ये सब नहीं देखना है. Only one thing that should play in their mind: how to do justice in this particular case. That's very important. That means judicial impartiality. On this much I wanted to say. These are the areas in which the Constitution should be visited. Thank you.